Adjournment request, if any, from item number 1 to 6.
May I please, Lordship? I beg to mention item number 5.
Item number 5.
Lordship, kindly adjourn the matter for the day.
No pressure. Yes. In fact, this court ordered for on 23rd of October as well as on 3rd of March to file another IA. You have filed the IA, but that is lying in defect.
Oh, sir, my senior English counsel is out of session.
But these are the matters which the juniors can also do it. We'll pick up the matters when the number comes. We'll pick up the.
From item number 7 to 16. Adjournment request.
May I please, Lordship? Lordship, with the consent of the other parties, Lordship, I beg to mention item number 17, Lordship.
17.
17, Lordship. My senior is out of station, Lordship.
That bail condition 43. UAPA
Yes, Lordship.
activity of that is under challenge.
Lordship. The matter can be fixed first week of May, Lordship.
Not May, then we'll fix it in July.
Sir, May first week.
This request is made on behalf of the counsel for the petitioner for adjourning the matter. The request is not opposed by the counsel for the respondent. Request for adjournment is not opposed by the counsel for the respondent. List it in July.
Humbly obliged.
Any other request?
My lord, I pray for listing of an income tax appeal, my lord, referred by a society of the state, my lord. Can it be on 10th, my lord?
10.
My lord.
Obliged, my lord.
I may appeal also. I beg to mention item number 11, my lord.
11.
11.
Last
My
time,
lord, the matter may be taken up after Bihu.
short time, the last time also.
Mr. Jayabdin will appear in this case. He is not well.
This 2011 provincialization under the Act of.
Ah, yes, my lord, yes.
July.
After Bihu, my lord.
July. Request is made on behalf of the counsel for the appellant. Seeking adjournment. Other party has not opposed. It is in July.
Complex.
May I please, the Lordship? I beg to mention listing of a rate appeal, Lordship. It relates to non-payment of pension. It may be listed immediately after the vacation, Lordship.
You vacation the register and list it. The register and list it. Is there any problem? The register is not listing it.
No, Lordship. And it was last listed on 4/3/2025, Lordship. Much obliged.
After being vacation.
Yes.
Yes.
Daily list for this item 1.
In pursuant to the last order, they have to.
Status report was.
My lords, I have a status report. We have cleared 628 acres till now, my lords.
File an affidavit.
But we'll file, my lord, just for lordship perusal.
Give a copy to the other side.
Yes, copy already furnished, my lord. We are bringing in color photographs, my lord, affidavit. Range wise, forest wise, it has been described.
Yeah. Learned concept.
Look.
Mr. Gogoi.
Yeah, this should be.
Preparing for the forest department. And submitted the latest. Actual report. Ready. The efforts carried out by the forest department to
Yeah, I need to.
remove the encroachments over the forest land. in the Nalbari Reserve Forest under the Lakipur Range, Gopalpara, Gwalpara Forest Division has been mentioned. Learned concept for the Mr. Gogoi is directed to file the actual report along with the additional affidavit.
My lord.
Of the officer concerned,
My lord. Obliged.
just after 3 weeks.
Deeply obliged.
Obliged.
I click on file.
Item number 2.
Order has been complied with, my lord.
Yes.
Complied with, my lord.
Complied to Lordship.
Yeah. Salary has been paid.
Lordship, areas are paid, Lordship.
Yeah, learned counsel for the petitioner as well as the counsel for the respondent have submitted that the order passed by this court has been substantially complied with, and the arrears of the salary has been paid to the petitioner. Full stop. A report, a communication dated 10/3/2025 addressed, written by the, sent by the Joint Secretary Government of Assam Department of School Education, addressed to the Accountant General A&E Assam, is produced on record. Is produced, which is taken on record. In view of the above facts and circumstances, this contempt petition is closed. Notice is discharged.
Obliged, lordship.
Item number 3.
May I please, lordship, my lord, steps has been taken, we have taken steps already. Government has filed one review petition, my lord.
Review petition,
Yes, ma'am, they have filed, we have received the copy.
but is there any stay that review petition?
No, my lord, no stay.
Then
It's not that, perhaps, my lord, will. Let it come up after review, my lord, then we spend.
just to take fresh steps
Yes, my lord.
for service of notice upon the respondent.
Fresh steps, again, my lord.
Learn counsel for the petitioner, it is noticed that
We have taken steps, my lord, on failure.
the notices issued to the respondents have not been certain. Then counsel, wherein the petitioner is granted a week's time to take fresh steps for service of notice upon the respondent number one, upon the respondents. On taking such a step, as notices be issued to the respondent, returnable jointly.
Item 4.
May I please, Lordship, I have taken the steps on the sole respondent, Lordship.
Then,
Lordship, today, due to some misunderstanding, the steps was taken in the wrong eye.
here, learned counsel appearing for the applicant has submitted that steps have already been taken as per the direction given by this court on 3/3/2025 for us to check, and if the steps have been taken, let notices be issued to the respondent to returnable.
Much obliged, Lord.
Item number 5.
Interlocutory application seeking leave. You are not filed,
I'll read.
but it is in defect. As per the interlocutory applications referred on behalf of the applicant seeking leave from this court to file appeal. Though filed but suffering from certain defects. Learned counsel for the applicant is directed to cure the said defects. List this matter after 2 weeks.
Item 6.
You are appearing for the sole respondent.
Yes, Lordship.
Service is complete now. What is this?
Lordship, regarding the IA, Lordship, we have objection, Lordship.
Have you filed any written objection?
No, Lordship will file
How many days delay is there?
331 days, Lordship.
Okay. Ms. So is appearing on behalf of the sole respondent. Service is therefore complete. The consent for the non-applicant pays some time to file, reply to these. Time frame for is granted just after 3 weeks.
Item 7.
May I please, Lordship, as per office note dated 5th of April, Lordship, service on respondent number 2 is complete.
Number 1 is not,
1 is not completed, Lordship.
await return of notice of respondent number 1 for 4 more weeks.
Lordship. Alright.
Item 8.
Lordship, as per last office note dated 5/4/25, neither the ID card nor answer notice has been returned back.
Who is appearing for the secondary education? This notice upon the director is already served. You are appearing.
I can appear, Malak. I can appear,
Contempt
Malak.
petition.
I can appear, Malak. I have no wakalat number today, Malak, but I can appear, Malak. I will obtain the
Yeah.
wakalat number.
Affidavit is filed. Affidavit for custody service is filed on behalf of the petitioner, and as per the same, the notice upon the sole respondent has been served. So, Mr. Katniar put an appearance on behalf of the sole respondent, service is therefore complete. He may, Mr. Katniar may file response to the writ petition. Kitna time? How much time?
3 weeks, Malak.
3 weeks. Just after 4 weeks.
Oblige, Lordship.
Item 9.
This is an I in the writ appeal, pending writ appeal. I'm actually for the respondent.
You have filed this IA,
I'm for the respondent. I have moved an I.
65 and 60.
Yes, 65 and 60, who were not initially impleted, but subsequently they were impleted. And let notice be issued on the IA, because my learned friend informed me that there was some bereavement in the lead petition counsel's family. So let notice be issued and some date be fixed.
Issue notice of the IA number 6/2025 to the non-applicants. You are appearing for?
It's for the appellant.
So he's not the appellant is not non-applicant.
Appellant is the non-applicant. I am the applicant.
You are the applicant, but he is the non-applicant.
Yes.
Returnable.
Let
Registry-
be served on I. Copies of the I we will.
Because जो appear हो रहा है वो जो appear हो रहा है उनका presence लगा के copies you serve.
I will serve. I will serve. I should make. May I request for a date, specific date, your lordship, subject to convenience?
June में date
Yes.
June.
For admission, item 10.
Please, Lordship. Family pension matter, my lord. Petitioner is the appellant is the second wife, my lord. Impugned judgment reveals, my lord, first wife will draw the family pension and disburse the same, my lord. My lord, after death, my lord, second wife was driven out.
Returnable, you are appearing for?
For the office of the accountant general, I have no role to play in the matter.
No, nobody is appearing for the private respondent.
I'm not sure.
You should notice, Mr. So put an appearance on behalf of the respondent, accountant general. Let notices be issued to the other respondents, returnable 6 weeks thereafter. The registered AD in the state, returnable 6 weeks.
Development.
Item 12.
Please, your lordship. On last occasion, they were to verify the PPO forwarded to the bank.
Yes. Who is appearing for the respondent? Chakravarti. Mr. Chakravarti. Pass over for the time.
Item 13.
Well, here, lordship may kindly give me 2 weeks' time, but they have filed a reply to our affidavit. We have brought on records the status report of the work. They have disputed that, my lord. I am awaiting the instructions in their reply. Kindly give me 2 weeks' time, lord.
You have to clarify.
That's true, my lord. But on the reply, my lord, I'll have to take the instruction.
Okay, learned counsel. Appearing for the respondent, there's some time to file. Counter to the additional affidavit,
Yes, my lord, they have filed an affidavit in reply.
which date? Affidavit in reply.
On 7,
We have filed 7 March.
The affidavit in reply. The counter to the affidavit in reply filed on behalf of the. Here, there's some time to file counter to the affidavit dated 7/3/2025. Referred on behalf of the petitioner.
Yes.
Referred on behalf of the petitioner. Time paid for his grant. Just after 4 weeks.
Item 14.
The lordships, we pray for 3 weeks' time to file affidavit in reply.
File for?
Affidavit in reply.
Learned counsel appearing for the petitioner, place some time to file counter to the affidavit in reply filed on behalf of the respondent. Time paid for is granted. How much?
3 weeks' time, your lordship.
3 weeks.
Item 15.
This matter, my lord, affidavits have been exchanged and the issue is otherwise fairly covered in my humble understanding.
On the last occasion, on 3 occasions, we paid some time to file rejoinder.
We have filed.
In fact, I have received it on Friday, lordship. I would be needing some.
Not on record.
Recorded on? We have filed it last week.
It is not on record.
In that case, let it come along with the.
Learned counsel. For the petitioner, it submitted that the rejoinder has already been filed, however, the same is not on record. Learned counsel. However, as per the office report, no rejoinder affidavit has been received till date. Learned counsel for the petitioner may check, and if the rejoinder is not filed.
It has already been filed. Last week itself we have filed. In fact, online it is being reflected.
Sorry. The opportunities were granted, opportunity was granted to the petitioner to file rejoinder. However, as per the office report, the same has not been filed till date. learned counsel appearing for the petitioner has submitted that the rejoinder affidavit has already been filed. The registry is directed to check, and if the rejoinder affidavit is filed, the same be placed on record. Based on. And. Start with you.
On 30th.
In the meantime, if you want to file.
Yes.
You may file.
Supplementary list for orders item 18.
You may take up item number 19 first.
19.
19.
My lord, I have a prayer, my lord. I understand I have been included as respondent number 2 in my capacity as a president of the Guwahati High Court Bar Association. And I also understand the allegation against me is I have not attributed any anything which amounts to criminal contempt. But as a president of the Bar Association, I have not taken any action. That is why I have been implicated as respondent number 2. Now, my lord, before my learned friend starts, I have few objections. Now, first of all, I would be obliged if a copy is given to me because I don't have a copy. Now, this petition has been filed in what capacity? Section 15(1) of the Contempt of Court Act envisages 3 situations when a criminal contempt petition can be filed. 1, of your lordship's own motion. 2, on the motion of the Advocate General. 3, somebody else can, any member of public also can file, but that must be supported by consent of the Advocate General. Now, in this case, if this case falls under which category? Because in the registry from what we got, my lord, it says Advocate General petitioner number 1, Devojit Saika petitioner number 2. So an individual and Advocate General both cannot join hands. Therefore, this is a petition under which provision?
Mr. Chaudhary, whatever your objections may be, until and unless this court takes any cognizance, whether these objections can be heard.
No, I was
The objections you are raising,
yes.
whether these objections can be heard at this stage.
No, my lord.
Until and unless the court takes cognizance,
True.
then
If
only right of
no,
audience.
if
is
your
available.
lordship does not take cognizance, end of the matter.
That is another thing.
Yes.
But first of all, until and unless we take in cognizance, then only you will get a right of audience, whatever, who are the respondents.
No, my lord. What I
Prior to that, where is the procedure, sir, to give?
no, my lord. There is one more. There is one more aspect, my lord. Number 1, the Advocate General can set in motion the law.
Yeah.
After that, Advocate General has no role.
That is what
He
the
need
law-
he need not come here to argue the case.
it is for your lordships to take a call.
Between the contender and the court.
Yes.
That's right.
And secondly, my lord, as the Supreme Court says,
And can very well come if the court is not satisfied with whatever the arguments, and then the court can ask to lead further evidence in support of the allegation, then his role is very much there.
no, it is there. No, my lord. I don't think that even that is there, my lord. Now, the question is, the motion will be brought to your lordship's notice. As Supreme Court judgment says, my lord, either of the three way it can be. Now, it appears, let us take it, it's a case where Advocate General has set in motion the motion, my lord. Now, then, my lord, registry will scrutinize it. Then it will be placed before the honorable lordships.
That has already been done.
No, I'm saying that, my lord. Thereafter, my lord, it will become. But now yesterday mention was made. In what capacity mention was made?
Every day mention.
No, my lord. No. That is not the procedure. No mention. What, has he got any personal animosity with anybody?
That you
No,
raise
not-
this objection very well, sir.
Hmm.
We are not passing
No.
here and the
No,
orders.
I agree. No, what I'm saying.
We'll simply, if we find that any case is made out,
Hmm.
we'll issue a notice, then you'll get all the right to defend. This
No,
contempt
what I'm
petition,
saying is, my lord, the fact that the proper procedure has not been followed, why your lordships will entertain
sir.
this?
Then you raise this objection, will certainly not entertain this petition, will drop the proceedings immediately. First of all, let us apply our mind, sir. And when we issue notice, then you will get the right of audience.
Not
sir.
true, my lord. Because, my lord, because yesterday's statement was made, the Advocate General himself was not aware as to what is the procedure. If he is ignorant about the procedure, he cannot set into motion a provision, my lord, which is so draconian.
That's why only, sir, in case this court take cognizance, then certainly you have all the objections at your hand. You can take these objections, will consider it.
No, my lord.
And if we find that no case is made out, certainly we are supposed to drop the proceeding.
Right. No, that is there, my lord. I'm not saying.
Once the motion is there, we have to pass an order, sir.
No, my lord, I was wondering only one thing, that lordship will take a call, my lord. Now, is it required for the Advocate General to move the motion? I am on that, my lord.
Sir, that is.
And especially when petitioner number 1 is the Advocate General, petitioner number 2 is the Deposit Saikia.
Raise this objection in writing, sir. We'll deal with it, everything, sir. But let us examine. them.
Okay.
We are not here that,
No, I
simply we are not passing any order.
No, I know.
Only preliminary hearing is there, sir.
Yes.
So Lordship, with a very heavy heart and with utmost humility, as an Advocate General Lordship, I have to move this motion under a very unwarranted and unfortunate circumstances. So with all humility, let me move this application. This application is moved under the provisions of 15A. I'll place the provisions little bit later. Let us first take up the issue. Who is the petitioner? The petitioner is the Advocate General, and who is holding that office? The name is given at number 2. And if Lordship is pleased to come to paragraph 2, let us see paragraph 1 and paragraph 2. Suppose there is a change of Advocate General tomorrow, whether that Advocate General will still continue or not. That is why the name is given. But let me place it 1 and 2. The petitioner number 1 herein is the Advocate General of the State of Assam, acting under the authority vested in the office, hereby files this contempt petition against the respondents for alleged contempt of court. The petitioner number 2 is the person presently holding the post of Advocate General. So just to give the identity, nothing else. And if Lordship feels that 2 should be struck off, I have no objection to that. That will not make the petition non-maintainable. As an abundant caution, we have given the name also. Because otherwise, if we had not given the name, the objection would have been the reverse. So that is. So with this unfortunate situation has taken place now, that is why I have to take up this step under the statutory provisions of the Contents of Court 1971. Although it is not a very happy situation, but let me move it, Lordship. Recently, Lordship, on 24th of March, I have come across a television program called Mazmel in Prague News Channel. And where it has come to my notice, and I have watched it also, that some very derogatory and defaming statements are made by one advocate of this High Court, which is named as Respondent number 1. She made this statement before the television journalist, and the transcript also I have annexed, as well as the video to the in a pen drive. I have annexed that also, and I have given a certificate under the provisions of BNS. So all these technicalities we have fulfilled. What she stated during a So that certificate, Lordship will find at page 18, certificate filed by the petitioner under the provisions of that, given the telephone number, etc., which is a mandatory. Earlier it was section 65, now it is a different provision. So we have stated the allegations against the respondent number 1 at paragraph 5 and 6. Lordship may kindly take up my petition.
Yes.
May I read paragraph 5 and 6? This is against R1, and R2, I have different paragraphs. The respondent number, contender 1, herein namely so-and-so, an advocate by profession, having her bar license number so-and-so, and a member of Guwahati High Court Bar Association, was not only heard and seen making statements in the said news channel program and circulating video clippings in social media platforms, declared that the proposed shifting of the High Court was based on vested interest. The respondent number, contender number 1, had even gone to the extent by stating in clear and unambiguous terms that there was a betrayal, see what I use, Bibhikhon, from within the judiciary. But to the utter shock and sadness, the said respondent, contender number 1, crossed all limits of decency and propriety when she nicknamed a particular judge as Chika, which in vernacular is for rat, and ultimately naming a judge of the Honorable High Court, disclosing that she nicknamed the Honorable Judge so-and-so as Chika. In the said video in circulation, she even heard criticizing the conduct of the said Honorable Judge in his court proceedings. That further, all barriers of humility and decency were broken by the said respondent number, contempt number 1, when the Honorable Judge was referred as managed master and was stated to be managing the registry with regard to listing of cases. The above remarks have, if considered to be with the best of intention, was directed to undermine the Honorable Court, the Honorable Judges, and the dedicated registry. In fact, the remarks made and the manner in which they were uttered in a particular forum, scandalizing the court and the judges, has given rise to discussion and dialogues in public, touching upon the dignity and integrity, majesty of the Honorable Court. Now, Lordship, that transcript at Annexure A, Annexure B, Lordship, I'm so sorry. Annexure B, that transcript, may I read it, Lordship? We have translated it. If the other side gets an opportunity, they can find fault in the translation also. Page 17. So this is the English version. Bibhikhon Sank Lanka, Bibhishan was the main reason for Ravan's death. In the same way, a Bibhishan is sitting amidst us who is playing bureaucratic politics, manage master. Reporter asked, who is doing that? Everyone knows that. I have named him Rat. Reporter, the one who went with Chief Justice. Then the response was, he. Everyone knows he who went. Honorable Justice so-and-so. If I show you copies of orders of so-and-so, there will be adjournments of 11, 12 cases should come after 11, 12, but he will manage to bring cases 11 and 12, which is regarding the manipulation of the registry. Who is not only putting knots on the stomach of advocates, but also causing discomfort, not only to the litigants, but also to public. Yes, we want land space. Why is it not available? There was a Asuka Hotel and the Circuit House nearby. Now the bungalow of so-and-so is also vacant. Could it not be given there? Forest land was also there. Can they not give it to us? Every wall of the CGM is crumbling, almost killing people. One employee was stuck, unconscious. Could not the CGM be repaired by new construction, shifted temporarily? There are a lot of places nearby, but without doing that, discomfort is being caused to everyone. There is Hitlerism politics going on here. That means in the court, the Hitlerism politics is going on. Reporter, thank you very much. If the then she responded, if the Hitlerism is not stopped there, it will be discomfort not only to lawyers but to public at large. Why? Because when a citizen comes in litigation to High Court, he comes with lot of hope and it is a center place. It can be reached from all sides, but instead of doing that, they are shifting it to North Guwahati for their vested interest. The land in North Guwahati has been shown to many big companies, but because the land is bumpy, they cannot, and finding no way out, they want judicial city. For what? Vested interest. It is not personal, it is vested interest. She is repeating. So this is the statement, Lordship, from where we can very easily adduce that some very derogatory and defamatory statements are made, and also scandalizing the registry and the Honorable Guwahati High Court. So now so far as respondent number 2 is concerned.
Yes.
So the respondent number 2, may I read paragraph 7, because I have made paragraph 7 against respondent number 7. The respondent number content number 2 herein is the president of Guwahati High Court Bar Association, which had organized the sit-in demonstration program on 24th March. From the platform stage of which the respondent number contender made above narrated statements, and the news channel program Masmel was prepared on the basis of statements made by the various advocates present in that sit-in demonstration program. Be it stated that although the respondent number 2 herein had not been heard stating anything directly contemptuous to the Honorable Court, the contempt of court alleged referred above by respondent number 1 herein was committed apparently with consent and connivance of the respondent number contender number 2, as during that period he was seen not making any attempt to stop or restrain the respondent number contender number 1 from making such statements. Which are out and out contemptuous of the court. The respondent number contempt number 2, being the president of the organization, organizing the said sit-in demonstration program, making statements before cameras as the representative face of Guwahati High Court Bar Association, and being present there during the entire sit-in demonstration, he cannot be let loose from the consequences of such contemptuous statements by respondent number 1. Such consent and connivance of the respondent / contempt number 2 is also apparent from the fact that till today, the Guwahati High Court Bar Association and its president had neither condemned the statements made by respondent contempt number 1, nor it has apologized till date for such contemptuous statements made by one of its members from the platform of Guwahati High Court Bar Association. Further, even if it is presumed, although not believable, that the contempt committed by respondent number 1 was without consent or connivance of respondent number 2, he cannot claim immunity, as utterance by respondent number 1 could not have taken place if the negligence would not have been there, on the part of the organizers and the respondent number 2 being the president of the organizing association. Accordingly, he shall also be deemed to be guilty of the same contempt committed by respondent number 1 as per the mandate of section 12(5) of the Contempt of Courts Act 1971. In addition, said respondent contempt number 2 is also liable as per the principles of vicarious liability. Now coming to paragraph 8. Lordship will kindly come to page 9, the subpara. The word spoken by the respondent number contempt number 1 is an act which has scandalized, prejudiced, interfered, and tends to obstruct the due course of judicial proceedings of court and the administration of justice, and accordingly it amounts to criminal contempt, and the respondent number 2, being the main organizer of the sit-in demonstration program, is also liable for the same offenses under sections 2C and section 11(5). Now coming to paragraph 11. Even as the aforesaid contemptuous acts was committed on the forum arranged under the aegis of Guwahati High Court Bar Association, the said association has not initiated any steps till date to condemn the said remarks which were made on a podium arranged by the association. The contempt number 2 had issued a notice on 26/3/2005 stating that the association was not responsible for personal views being expressed by individual members, but unfortunately, there was no indication of such statements were either disowned or that such action was being condemned in any matter whatsoever by the association. It is thus apparent that though the statements was made by an individual, the same had the support of the respondent number contempt number 2, in as much as neither had the respondent number contempt number 2 taken any steps to interrupt the contemptuous utterances of respondent number 1, nor were any efforts was to ensure that such contemptuous statements were stopped from being made public. Such deliberate resistance, that means omission, from even attempting to keep the statements in containment exhibits that the respondent number 2 had acted in connivance and in hand in glove with the respondent number 1 with an intention to destabilize the functioning and majesty of the judicial system. The malicious and politically motivated intent of the contemners are also exhibited when they allowed politically active persons. There are lots, if required, I will name them also with photographs, to participate in the said sit-in demonstration, although such persons are wholly unconnected with the cause depicted to be espoused in sit-in demonstrations. The actions and inaction of respondent number 2 indicate that the entire attempt was to seek focus in a recorded slander and to display a picture of support of the contemptuous speech being delivered by respondent number 1. And as such, both respondent number 1 and 2 present during such contemptuous act are liable for committing criminal contempt of this honorable court as defined under section 2C of the Contempt of Court Act 1971. Paragraph 12, last 4 lines. Contemptuous act committed by advocates in public forum with the intent to malign the judiciary, more particularly this august institution of Guwahati High Court and its judges, is wholly condemnable and ought not to be forgiven or overlooked. Then paragraph 14, Lordship will kindly come. We have made a specific paragraph. It is stated that a translated version of the transcript disclosed malicious statements made by contempt number 1 to malign the image of Guwahati Honorable High Court and judges, and the medium and manner of expression leave no doubt that the same were deliberately made to erode respect and confidence of the public towards the judicial system. The following statements assumes importance. So I have given that statement, which I have already read from that script. 15, the above statements are vulgar, offensive, outrageous, and have the undoubted tendency to lower the authority of the honorable court and the judges. So this is the basic pleadings in the contempt petition. So now let us examine what is the law and what are the propositions of the various judicial pronouncements in this regard. Before going to the law as well as the proposition laid down by the Honorable Supreme Court, I would like to also place the other case, the factual differences, the transcript. May I read it?
Is this translation you have certified, is this translation is as it is?
It is translated, Lordship.
Hey, do you have the pen drive?
Pen drive we have given, Lordship. It is there.
Do you have a copy of pen drive with that? The copy of.
I have a copy with me also, and
Place it on the.
it is
play-
a part of
play
the
this
record.
video. We'll play this video. Arrange this.
Yeah, look at it. May I, this is my copy, so I can give it. The পানি খুয়াই দিতে আমি করবো। পানির bottle. Yeah, one more. I have a technical team, Lordship, they will assist. Because it is a very long, but particular timing is required.
You need not to bother, we also have a technical.
Lordship.
You need not to bother, we also have a technical team.
No, no, because my pen drive is given. Only it is not the playing, the actual, the very long duration, the particular timing. Otherwise, we have to consume lot of time to see the whole.
The, which you are highlighted in this. picture.
Yes, Lordship, that part, Lordship. তুমি মোক পঠিয়াইছিলে না 8 মিনিটৰ পৰা 8 মানৰ পৰা from 13th minute the lady advocate's version is there.
উপস্থিত আছে বহুত মই কেছ কৰিব আগতে বুঝছো মোৰ ওপদাই মাতে আন্দোলনৰ পথ এক প্ৰকাৰ শেষ ৰাস্তা আপোনালোকৰ হাতত আছে মুখ্যমন্ত্ৰীৰ লগত চৰকাৰ যাৰ চৰকাৰৰ লগত আপোনালোকে আলোচনা কৰিব পাৰিলে কিন্তু আপোনালোকে পুনৰ পথ ল'বলৈ বাহিৰৰ
Statement of that lady.
Yes,
This lady.
it can go forward.
Where is the statement?
Go. Go ahead. Go ahead. গৈ থাকক। আছেতো, আছে নে নাই?
এই পিছতে মই
Come little bit before. অলপ আগুৱাই দিয়ক।
অলপ আগুৱাই দিয়ক।
Lordship, if it comes to the first 8 minutes, then the other petitions version is also there, other Senior Counsel Anil Kumar Bhattacharya's
That
statement,
will, when we'll come with that case, then we'll,
Lordship.
this is end here.
Yeah, Lordship,
Stop it.
because of whatever I have given already said, word by word is same.
That,
Eternal.
yes, stop it. Yes.
So now let us see what are the provisions of law, Lordship. Section 2C. Contents of Court Act 1971. Definition, section. Criminal contempt. What constitutes a criminal contempt? Criminal contempt means publication, whether by words, spoken or written, or by signs, or by visible representation, or otherwise, of any matter or doing of any other act which whatever, number one, scandalizes or tend to scandalize or lower or tend to lower the authority of any court. So any court will also be a high court. Everything 12.
Yes.
Section 12, punishment for contempt. That Lordship will decide later on if we could establish the case.
Definition, read the whole definition.
Lordship.
Criminal contempt, read the whole definition.
Then 2, prejudices or interferes or tend to interfere with due course of any judicial proceedings. 3, interferes or tend to interfere with or obstruct or tend to obstruct the administration of justice in any other manner. So it will come under 1 and Roman 3. And High Court means High Court of a state or union territory and includes the Court of Judicial Commissioner in any union territory. So 2C1, I have said only 2C. So it will include also Roman 1 and Roman 3. Now, Lordship, okay, section 12 is punishment for contempt of court. I'm skipping that part for the time being. Now I'm coming to section 15.
Yes.
Cognizance of criminal contempt in other cases. There are other provisions under section 14, which we are not entitled to do. Now we are on 15. 1. In case of criminal contempt other than contempt referred to in section 14, the Supreme Court or the High Court may take action on its own motion. That option is definitely with Lordship, or on a motion made by A, the Advocate General, or B, the other person with the consent in writing to the Advocate General. So I had that option also. If somebody had written, would have given a concurrence. And 3, in relation to High Court of Union Territory of Delhi, such law officer that we are skipping, we are not. Now coming to Roman 2, that 2. In case of any criminal contempt of subordinate court, the High Court may take action on a reference made to it by the subordinate court or on motion made by the Advocate General or in relation to a union territory by any such law officer as the central government may, by notification in the official gazette, specify in this report. 3, every motion or reference made under this section shall specify the contempt of which the person charged is alleged to be guilty. And in case of Central Supreme Court Lordship, the Advocate General also includes Attorney General and the Solicitor General. So that is the note. Now, let us place the law which is in force. In the recent case of Prashant Bhushan Lordship, 2021, 1 SCC page 745. All other previously important cases relating to this provision, Lordship, are discussed in this. 2021, volume 1 Supreme Court cases, page 745. And this is a judgment delivered by 3 honorable judges, Justice Arun Mishra, Justice V.R. Gavai, and Justice Krishna Murari. So I would like to place few paragraphs of this judgment that will clarify the overall legal position, whatever maybe the other side will say. But my case will be basically dependent on this case, but I have other 5 cases also to cite. So paragraph 1, the basic facts in that case, one small tweet of Prashant Bhushan, which led him to face criminal contempt proceedings. 1, a petition came to be filed, paragraph 1, Lordship. A petition came to be filed in this court by one Mahek Maheshwari, bringing to the notice of this court a tweet made by Mr. Prashant Bhushan advocate, alleged contempt number 1, praying that to initiate contempt proceedings against the alleged contemptor for willfully and deliberately using hate, scandalous speech against this court and entire judicial system. Lordship will kindly come to that within bracket. What was the tweet? The tweet was, CJI rides a 50 lakhs motorcycle belonging to a BJP leader at Raj Bhavan, Nagpur, without a mask or helmet, at a time when he keeps the Supreme Court in lockdown mode, denying citizens their fundamental rights to access justice. So this was the tweet. In this case, the Attorney General did not give the concurrence, so the Honorable Court took it as a suo motu matter. Now, coming to paragraph 5 and 6, sorry, paragraph 66. I'll go haphazardly, Lordship, because I want to actually clear what is the exact position of law in this regard. Paragraph 66 first. Paragraph 66, it will be in page numbers 797. Elaboration of that particular fact. We have reproduced both the tweet in order dated 22/7/2020.
Which was the other tweet?
Lordship.
Which was the other tweet? You only read one tweet, pointed out one tweet. Which was the other tweet?
The
Because
second is also. The second tweet is
Both the
also in
tweets.
paragraph 1.
Where is that? 2-4.
In paragraph 1. Paragraph 2, Lordship will kindly see. When historian in future.
Yes, then. Yes. This
When
is-
historian in future look back at the last 6 years to see how democracy has been destroyed in India, even without a formal emergency, they will particularly mark the role of the Supreme Court in its destruction, and more particularly the role of last 4 CJIs. So this is the second part. But court have basically gone into this first part while deliberating. Now, coming to paragraph 66, we have reproduced both the tweets in the order dated 22/7/2020, which is reproduced in the beginning. The first part of the first tweet states that CJI rides a 50 lakhs motorcycle belonging to BJP leader at Raj Bhavan, Nagpur without a mask or helmet. This part of the tweet could be said to be a criticism made against the CJI as an individual and not against the CJI as CJI. However, the second part of the tweet, at a time when he keeps the Supreme Court in lockdown mode, denying citizens of their fundamental rights to access justice, undisputedly, the said part of the statement criticized the CJI in his capacity as the CJI of India, that is the administrative head of the judiciary of the country. The impression that the said part of the tweet attempts to give a layman is that CJI is riding a 50 lakhs motorcycle belonging to a BJP leader at Raj Bhavan, Nagpur without a mask or helmet at a time when he has kept the Supreme Court in lockdown mode, denying citizens their fundamental rights to access justice. The said tweet is capable of giving an impression to a layman that the CJI is enjoying his ride on a motorcycle worth 50 lakhs belonging to a BJP leader at a time he has kept the Supreme Court in lockdown mode, denying citizens their fundamental rights to access justice. So now coming to paragraph 69. In this premise, making such wild allegation, thereby giving an impression that the CJI is enjoying riding an expensive bike while he keeps the Supreme Court in lockdown mode and thereby denying citizens their fundamental right to access justice is undoubtedly false, malicious, and scandalous. This is a finding. Now coming to paragraph 22 now. Paragraph 22.
22 of this judgment,
Same judgment. I'll go here and there, Lordship. Lordship will kindly excuse me.
you always go here and there.
Page number 776.
Yes.
The Constitution bans thus hold that a publication which attacks on individual judge or the court as a whole, with or without reference to a particular case, casting unwarranted and defamatory aspersions upon the character or ability of the judges, would come within the term of scandalizing the court. It is held that such a conduct tends to create distrust in the popular mind and impair confidence of the people in the court, which are of prime importance to the litigants in the protection of their rights and liberties. It has been held that it is not necessary to prove affirmity that there has been an actual interference with the administration of justice by reason of such defamatory statement, and it is enough if it is likely to or tend in any way to interfere with the proper administration of justice. Then Lordship will kindly come to paragraph 38. Paragraph 37, then 38. Page 785. As rightly pointed out by Sri Dave, the Constitution bench in Barakananda Mishra holds that when proceedings in a contempt are taken for vilification of a judge, the question that the court will ask itself is whether the vilification is of the judge as a judge or if the vilification of the judge as an individual. In the latter case, the judge is left to his private remedies and the court will have no power to commit for contempt. However, in the former case, the court will proceed to exercise the jurisdiction of the scrupulous care, and in case which are clear and beyond reasonable doubt, it has been held that the jurisdiction is not intended to uphold the personal dignity of the judge. However, if the attack on the judge functioning as a judge substantially affects the administration of justice, it becomes a public mischief punishable for contempt, and it does not matter whether such an attack is based on what a judge is alleged to have done in the exercise of his administrative responsibilities. It has been held a judge's functions may be divisible, but his integrity and authority are not divisible in the context of administration of justice. It has been held an unwarranted attack on him for corrupt administration is a potent in doing public harm as an attack on his adjudicatory functions. The Constitution bench, paragraph 38, the Constitution bench came to the conclusion that a vilificatory criticism of a judge functioning as a judge, even in pure administrative or non-adjudicatory matters, amounts to criminal contempt. In the case, it is not.
I mean to say that as per this judgment, even personal remark on a particular judge would also come within the definition of scandalizing the court.
Absolutely, number one, when he is functioning as a judge. Here, it is not a judicial, one party judicial proceeding, that listing of cases through the registry, that managed master thing. But the other part is regarding his role as a Bibhikon and etc. A lot of things are said, which I do not want to repeat. There, his part is that he is doing his function in the role of as a judge responsible for administration of the justice system. If we look at the whole, he is going to a particular meeting also has part of that conversation or that statement. So it may not be only regarding delivery of judgments, but it is also his role as an administrator of justice also. That will also lead to criminal contempt. Paragraph 38, now paragraph 58. Just 10 minutes, Lordship, I'll finish. 58. The observation of the Constitution bench reiterate that the legal position that contempt jurisdiction, which is a special jurisdiction, has to be exercised sparingly and with caution. Whenever an act adversely affects the administration of justice or which tends to impede the courts or tends to shake public confidence in the judicial institution. In this case, Lordship, he is saying a lot of things against the judge as well as the institution. What repercussion will take place? What ramification that will take place in the mind of the general public who does not have much knowledge about the working of this system. So their last recourse is this court of law, which we say the temple of justice. And if they are denuding its majesty lordship, that will definitely lead to attract the provisions of criminal contempt. And in very clear language, what she is imputing against the judge or the system is contemptuous in nature. This jurisdiction may also be exercised when the act complained of the adversely affects the majesty of law or dignity of the courts. The purpose of contempt jurisdiction is to uphold the majesty and dignity of the court of law. This jurisdiction is not to be exercised to protect the dignity of an individual judge, but to protect the administration of justice from being maligned. It is reiterated that in the general interest of the community, it is imperative that the authority of the court should not be imperiled, and there should not be no unjustifiable interference in the administration of justice. It has been reiterated that no such act can be permitted which may have the tendency to shake the public confidence in the fairness and impartiality of the administration of justice. Next, Lordship will kindly come to paragraph 61. It could be thus seen. Now here there is an analysis of articles 19(1), freedom of speech, up to what level it is permitted. It is well settled that a citizen, while exercising rights under article 19(1), is entitled to make fair criticism of a judge, judiciary and its functioning. However, the right under article 19(1) is subject to restrictions under clause 2 of article 19. An attempt has to be made to properly balance the right under article 19(1) and the reasonable restrictions under clause 2 of 19. If a citizen, while exercising his right under article 19(1), exceeds the limits and makes a statement which tends to scandalize the judge and the institution of administration of justice, such an action would come in the ambit of contempt of court. If a citizen makes a statement which tends to undermine the dignity and authority of this court, the same would come in the ambit of criminal contempt. When such a statement tends to shake the public confidence in the judicial institutions, the same would also come within the ambit of criminal contempt. No doubt, when a statement is made against a judge as an individual, the contempt jurisdiction would not be available. However, when the statement is made against a judge as a judge, which has an adverse effect in the administration of justice, the court would certainly be entitled to invoke the contempt jurisdiction. No doubt, while exercising the right of fair criticism under article 19(1), if a citizen bona fide exceeds the right in public interest, this court would be slow in exercising the contempt jurisdiction and so magnanimity. However, when such a statement is calculated in order to malign the image of judiciary, the court would not remain a silent spectator. When the authority of this court is itself under attack, the court would not be an onlooker. Word authority, as explained in so-and-so, approved the constitution bench by this court in Barakadanda Mistress, does not mean that the coercive power of the judges, but a deference and respect which is paid to them and their act from an opinion of their justice and integrity. Paragraph next is Lordship 66 already, 74. As discussed herein above, while considering as to whether the said criticism was made in good faith or not, the attending circumstances are also required to be taken into consideration. One of the attending circumstances is to extend of publication. The publication by tweet reaches millions of people, and as such a huge extent of publication would also be one of the factors that require to be taken into consideration while considering the question of good faith. Paragraph 76. As held by this court in earlier judgment, to which we referred herein above, the Indian judiciary is not one of the pillars on which the Indian democracy stands, but it's the central pillar. The Indian constitutional democracy stands on the bedrock of rule of law. The trust, the faith, and the confidence of the citizens of the country in the judicial system is sine qua non for existence of rule of law. An attempt to shake the very foundation of constitutional democracy has to be dealt with iron hand. Although very unfortunately I have to move, but Lordship, The present situation demands iron hand. Paragraph 78, page 801, top lines, that Krishna Alliance one quote. As observed by Krishna Iyer, justice in as Mulgaonkar, on which judgment Sri Dave has strongly relied on. If the court considers the attack on the judge or judges Kerala's offensive, intimidatory, and malicious beyond a condemnable limit, the strong arm of law must, in the name of public interest and public justice, strike a blow on him who challenges the supremacy of the rule of law by fouling its source and stream. The summary jurisdiction of this court is required to be exercised not to vindicate the dignity and honor of an individual judge who is personally attacked or scandalized, but to uphold the majesty of law and of the administration of justice. So that tweet was considered paragraph 80. The tweet which was based on distorted facts is, in our considered view, amount to committing of contempt. Punishment was given, review application was filed, it was also dismissed. The law is well elaborated in this judgment, Lordship. In my humble submission, the statements made by the lady advocate is not a personal attack on Justice Suman Syam. She has attacked Suman Syam as a judge of this honorable court. Justice Suman Syam was attending some meetings with the government accompanying Lordship. That was put to question. She has also given him a very derogatory title, I should say, but which I do not want to repeat. In inverted comma, it is already there. What does it signify? When a person will come and a case is listed before that court, Lordship, and when that judge's name will be there, what trust or what confidence the people will have in that court now?
Yes.
So that word and manipulation of registry is a direct attack on this institution. And if this kind of, if Lordship is pleased to show leniency in this, this will encourage identical statements from other quarters in future. So as a constitutional duty, as a statutory duty, I have moved this application. I have no grievance against my senior colleagues for whom I have a lot of respect and love. But when it comes to the institution, it is my duty. So at this stage, Lordship may be pleased to issue notice. Other case statements I would like to place. The statements are very dangerous. Rest of the arguments are same. The same precedent is there in as respondent number 2. Only he's a very respected. I have learned a lot of things from him, but it's my duty to file this case against him also. Paragraph 13. Next statement to the council. Paragraph 5.
Yes. Yes.
Paragraph 5, Lordship.
Yes.
Page 4. The respondent contempt number 1 herein so and so, a designated senior counsel of this by profession and member of the High Court Bar Association, was not only heard and seen making statements in the said news channel program and in circulating video clippings of in social media, declaring that he has positive evidence of Justice so and so, and he behaves like a CID. In his statement, he further said, why all the time Justice so and so has to be friendly with Chief Justice? What is the reason? He, on being further asked by the reporter as to what evidence he has in support of his allegation, the respondent contempt number 1 commented that due to presence of large number of ladies, he was refraining from giving further comments. Otherwise, he would have replied the question very badly. He went ahead by stating that all the allegations are not required to be proved by citing evidence, by giving various examples. One of those was that no evidence is required to be asked as for the color of milk is white or black, overtly indicating that his allegation requires no further evidence. The above remarks have, if considered to be with the best of intention, were directed to undermine the honorable court the honorable judges and the dedicated registry. In fact, remarks made and manner in which they were uttered in the particular forum, scandalizing the court, the judges, has given rise to discussions and dialogues in public, touching upon the dignity, integrity, and majesty of the court. Lordship will kindly come to the transcript now. Page 17. The journalist asked, but Bhattacharya, sir, the Chief Justice of High Court and his learned brothers who were his colleagues went and sit in meeting with the Chief Minister and they had expressed consent. How have you accepted the event and they expressed their consent sitting in a meeting with the Chief Minister? Contempt number 1 says, I condemn this and they have not gone. Only 2 judges who is not even a member of the collegium, and why all the time Justice so-and-so has to be friendly with the Chief Justice. I have a positive evidence that he behaves like a CID. Then the journalist instigated to repeat the name. It was repeated. Then that evidence, the evidence part, he said all those things. May I read it, lordships? See, many ladies are here, otherwise I would have replied very badly. What evidence is there that he is not hairy everywhere? That I could not get the translation of this word. Would you ask that evidence has to be given whether milk is white or black? Does it require evidence? Why do people marry? Rule of marriage, one of is to procreation. Does it require any evidence? Ask that to the Chief Minister. To how many he has given evidence? Does he have any evidence that when he declared here, he is an invitee only? What authority he has to declare that and someone has brought out? I heard today morning that all the judges have not gone, only 5th and has gone there. So this is again institutional attack. Who is not even a member of the collegium is not. So this is not attack on Justice Suman Syam as an individual. He is challenging the system. Yeah. Muji Monjay Korai Thaga Taman.
Yes.
The 8-minute onwards, that video.
Let's play that video also.
Yes, Lordship. Break ka bar. This is break ka bar. The first one was one that is. It's a very serious matter, Lordship, but I'm taking it now. I have to take it. And there is nothing personal here, Lordship. It is for the institution. The Advocate General Assam has acted.
আপোনালোকৰ সকলোৰে পৰিচিত ইতিমধ্যে মেজমেলত তেখেতৰ এটা সাক্ষাৎকাৰ গ্ৰহণ কৰা হৈছিল শ্ৰেষ্ঠ অধিবক্তা অনিল কুমাৰ ভট্টাচাৰ্য ডাঙৰীয়া। অনিল কুমাৰ ভট্টাচাৰ্য ডাঙৰীয়া, আপোনালোকে আন্দোলনৰ পথ ল'বলৈ কিয় বাধ্য হ'ল?
From 8 minutes. অলপ আগুৱাই দিয়ক আৰু অলপ আগুৱাই আৰু অলপ আগুৱাই দিয়ক Back, back, rewind, rewind.
Eight minute. Minute eight over.
8 minutes.
He behaves like
আৰু অলপ আগুৱাই দিয়ক 1 মিনিট আগুৱাই দিয়ক 7 মিনিটৰ পৰা দি দিয়ক
more than 405 বিচাৰি পোৱা আৰু ইয়াতো যেতিয়া এই বিল্ডিংৰ হৈছে 405 missing. Unfortunately, like executive judiciary বিচাৰ আমি যেতিয়া ৰিটাই কৰি মাতি পঠাও নাই নেকি ক'ৰবাত আছে নেকি এনেকুৱা এটিটিউডত নাই হ'ব নোৱাৰে কিন্তু বৰসাদী ডাঙৰীয়া উচ্চ ন্যায়ালয়ৰ মুখ্য ন্যায়াধীশ আৰু তেওঁ ব্ৰাদাৰ্ছ সকল তেওঁ সতীৰ্থ তেওঁলোক গৈ মুখ্যমন্ত্ৰীৰ লগত আলোচনা কৰিছে আৰু তেওঁ সন্মতি প্ৰকাশ কৰিছে তেওঁলোকে মুখ্যমন্ত্ৰীৰ লগত আলোচনা কৰি সন্মতি প্ৰকাশ কৰাৰ কথাটো আপুনি কি ধৰণে আৰু তেওঁলোক যোৱা নাই মাত্ৰ দুজন ব্যক্ত will not even member of the collegium. And why all the time justice small has to be ready to be situated? What is it? I have a positive evidence that he behaves like a CID. No, justice small. আপনার কি প্রমাণ আছে? তাও এটি যাতে নলের খুব ব্যাক হচ্ছে কি প্রমাণ আছে এটা সকল কথাতে আপুনি বুজিব নেকি যে ৰাতিৰ ভোগানে গলে তাৰ প্ৰমাণ দিব নেকি মানুহে বিয়া বাৰু কিয় কৰায় তাৰে প্ৰমাণ দিব লাগিব বিয়াৰ নিয়ম মানৱিক প্ৰক্ৰিয়া সেইটো প্ৰমাণ দিব লাগিব সেইটো চিগনেচাৰ সোধক তেওঁ কিমানত প্ৰমাণ দিছে তেওঁৰ প্ৰমাণ আছিলে নেকি ইয়াত এতিয়া তেওঁ he is an invited only but authority he has to take that আৰু এইটো কোনোবা আজি ৰাতিপুৱা গোটেই বজাৰ যোৱা নাই ঠিক জাজ
ঠিক আছে
কলেজিয়ামৰ সদস্য নহয় এতিয়া এই গোটেই বিষয়টো কেন্দ্ৰ কৰি হাইকোৰ্ট বাৰ এছ'চিয়েশ্যন বিভাগত তেওঁ কিমানৰ প্ৰক্ৰিয়া সেইটো প্ৰমাণ দিব লাগিব সেইটো চিৰি কৰিব লাগিব আপুনি বুজিব নেকি
মোৰ নোটছিটটো যোনখন বহি আনিছিলো
কি প্ৰমাণ আছে লেডিজ আছে নহলে মই খুব বেয়া কি প্ৰমাণ আছে সেইটো সকলো কথাতে হেৰি নহয় আপুনি বুজিব নেকি যে গান
লৈ ল'ব দেই আমাৰ So nothing more is required to be said, Lordship. It's a fit case for issuance of at least the notice at this stage. We'll argue when the counter comes. What will make a scandalous comment? What is a fair criticism of the judiciary? And what is not permittable under the provisions of mandate article 19.2. What is 19.1 and 19.2? We'll distinguish. I'm deeply obliged for allowing me to place the complete facts. Highly obliged.
Yes. 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 Mr. Chaudhary. Yes. Before you start, please. Yes. Let us know where section 15 mandates to give a pre-audience to the person who has been included as a respondent in the contempt petition. Any law on this point? We would be very pre-audience before issuance of the notice.
No, my lord. Prima facie, your lordships will have to be satisfied that it's a case where section 15 is attracted. It is then only a question of issuing notice would arise. Today, my lord, I am not holding the brief for respondent number 1.
Certainly not.
I am holding the brief for respondent number 2, that is myself. Now, what is the allegation? That those statements were made in connivance with me. No,
That's why only, sir, we are
Yes.
just asking, that is for us to consider.
no, lordships will not reduce this proceeding to a triviality, my lord, because it's a very serious matter.
Because sir, section 15, if section 15 mandates
Hmm.
or any of the provision under the Court of Contempt
Yes,
Act mandates
yes,
that a pre-audience is required.
no, my lord,
Certainly, if
certainly,
mandates, we have to follow.
yes.
If
Then lordships,
such provision,
no, lordships will have to be satisfied
yes,
that whatever has been attributed to me comes within 2C.
sir, that is the question. When once we issue notice, suppose if we decide to issue.
No,
notice,
look, why
then only
today-
You have
today-
to, you have a full opportunity to demonstrate that whatever I have said or whatever the allegations may be against me or against any person, this offense is not made out. It is always,
No, well,
the
it is-
adjudication will come later on, sir.
It is not that your lordship issues notice as a matter of course in all cases. There are cases where lordship also seeks instruction before issuing notice.
No, no.
Now question is, lordship will be issuing notice
That
not
is the
against
process.
Kamal Nayan Chaudhary, but against the president of the Bar Association.
Fine.
It is in that perspective I'm making this submission. Kindly see, my lord, kindly see, my lord, this, my learned friends, consent, it is also justiciable. Please keep that in mind, my lord.
Which consent?
His consent,
Consent for what?
consent to, that he has, that his motion, that his consent is itself is justiciable. Yes,
Consent is
my
not.
lord, he is a partisan person. He is all throughout making statements in the TV channels. Everywhere he is making statements. The 3 persons are responsible for this. He has got personal animus.
Sir, if he.
No, my lord, lordship will hear me.
If he will be available.
Yes.
Satisfy us that these, he is doing all this.
Yes.
In the capacity of an advocate general.
Yes, even then.
And if due to his personal animosity. sir,
Yes.
Consider that.
No, my lord.
Not that this.
No, my lord will kindly have the judgment, 1988, 3 SCC 167.
Show us one judgment.
Yes,
Three
yes.
options is
No, I am
right,
showing,
then
my
we will
lord.
give it to you.
I am showing that judgment where the Honorable Supreme Court has said the consent is justiciable.
I think him very well.
He has got personal animus. That's why he has done this. Everywhere he is saying, my lord, that 3 advocates are responsible when the decision is of the bar. Lordships will not entertain such applications, my lord, when personal animus is involved.
Tell me if it is no case is made out, we'll drop the proceedings
No.
immediately.
No, my lord, I am against issuance of notice.
Issuance of notice, sir, you just show us that before issuance of notice, a pre-audience is required to be given, we'll give you the audience.
No, my lord, I'll show a judgment where the Honorable Supreme Court has said that your lordships must be satisfied before issuing notice.
Naturally, sir, we have to be satisfied.
Yes.
sir,
So what is
we
the
are
role?
doing, sir.
So what is the role attributed to me?
What we are doing, we are for.
No,
our
what is this?
satisfaction.
Mala, why not the whole association? I cannot, this lady advocate is not my employee, my lord.
No,
Sri Anil Kumar Bhattacharya, a person who is 85 years of age, I cannot control his thing, my lord. He is not my junior, he is not my chambermaid.
That's a maybe a difference. And
Please.
consider that.
Yes, no, my lord.
Pre-audience.
When things are done, having regard to personal animus, certainly lordships will not give credence.
And we will not take the matter, but at least.
Yes.
Before that, pre-audience, this requirement of pre-audience, you will just give us to us.
And my lord, where is the question of vicarious liability in a contempt proceeding?
That is his allegation. Still, we are not, that is his allegation. he has
So,
to prove.
so if there is no foundation in the case, why your lordships will issue notice against me?
Sir, that is the question. Please leave it to us.
Yes.
Then we will consider, but we are only on this point, sir. We are again, sir, politely we are asking, please show us any law which allows this court to give a free audience to a respondent, to a person who is included as a respondent in a,
Yes.
this contempt petition under section 15C.
Then Milord will kindly have 2004 4 SCC 573.
Yes.
Yes. Page 573, please come to para 9. Para 9 at page 579. The contempt of court is a special jurisdiction to be exercised sparingly and with caution whenever an adversely affects the administration of justice of which tends to impede its course or tends to shake public confidence in judicial institutions. Jurisdiction may also be exercised when the act complained of adversely affects the majesty of law, dignity of the court. Which act of mine has done this, my lord? That lordship is inclined to issue a notice. Then please come to para 10. Contempt of court proceedings should not be initiated lightly. Since in the present case, in the face of the infirmities noticed above, the impugned judgment and the order cannot be sustained, one course that can be adopted is to remand the case, etc., etc. So, my lord, this proceeding should not be initiated very lightly. Now, which is that, my lord, he is saying, in connivance with me, my lord, on that day, after my interview, my lord, I went to Shillong. Only when returning, my lord, I got to know this statement was made. Immediately, my lord, next day we issued the statement. I'll give the chronology, my lord. Yes. My lord, this telecast was made on 24/3.
Yes.
On 24/3, the telecast was made. I got to know on 25th while returning from Shillong. In fact, my lord, I was doing case. Then one of my colleagues called me that as a president, they want to, then I went there. Then I again came back to court and 2:30 I left. My lord, on 26/3/2025, bar issued that notice, disowning the action of that lady advocate, saying that we do not approve of it and this does not reflect the bar's view or opinion in the matter. And my lord, on 2/4/25, we have issued a show cause notice to that lady advocate, asking her to explain why disciplinary action should not be taken. But as a bar association, what can I do? Now, what is this connivance? Then if he is bringing connivance, then he's asking your lordships to do a roving inquiry. No, roving inquiry is not permitted in a contempt proceeding. Number two, my lord, there is no concept of vicarious liability. I place a judgment of the Supreme Court. No, before that, my lord will kindly come to.
Again, we are repeating.
Yes.
That shows the law which permits the court to give a free audience.
No, my lord,
a person.
I do not, let me make it very clear, my lord. I do not have any clear-cut authority saying that before issuance of notice, alleged contemptor has any right of audience. That's true, my lord. But my lord, the judgment which I have read out just now, there is a caution by the Supreme Court.
Judgment,
that,
in fact, this judgment, you are referring to this judgment of the year 2004, but the latest judgment in Prashant Bhushan case,
yes,
court has reiterated the very same thing. In many of the paras, sir.
No, my lord. No, my lord, question is, no, I'm talking from
the position of loss.
No, my lord, I'm talking from my perspective. The allegations attributed to me, does it attract section 2C?
Let us examine that, sir. Let us examine that, first of all.
No, prima facie, if prima facie your lordship is satisfied, I have got nothing to say.
Sir, prima facie satisfaction, still we have not shown a prima facie, even in respect of the other containers also. We have to consider it and then only will pass an order, sir.
Anyway, my lord, regarding vicarious liability, I am placing one judgment. Yes. That Supreme Court says, my lord, this concept of vicarious liability is alien to contempt jurisdiction. This is, my lord, 2022 1 SCC 101. It's a case arising from our High Court. Photo copy nahi nahi. It was. I'm having copies. Eight. Lord, after the long discussion, if your lordships would kindly come to paragraph number 10, my lord. There is no material. 4, 5, 6, 6 or 7 line. There is no material. Yes, if your lordships would kindly come to para 10, my lord. Yes. Please come to placidum D.
Yes.
There is no material to either establish their knowledge on the action of their subordinates or that they acted in collusion with each other. Vicarious liability as a principle cannot be applied to a case of contempt. Now, my lord, the allegation is, I as a president in connivance it was done. Where are the materials? Will your lordship do a roving inquiry to find out that? My lord, in a contempt proceeding, your lordship will have to be based on an established fact. So, my lord, on the face of this, the right of pre-audience hearing, my lord, that your lordships will take a call. But based on the averments made in paragraph 7, I don't think any case has been made out even for issuing notice. So there is no concept of vicarious liability. And I'm also making it very clear, my lord, I have every right to challenge the, consent of the Advocate General, because this is not, my lord, for upholding the, majesty of this court, but to wreak personal vengeance. For that, I'm relying on one authority, my lord. That is 1988 3 SCC 167. My lord will kindly come to page 192. This consent of the Advocate General is not merely the gospel's truth. This is subject to further scrutiny by your lordships. My lord, paragraph 38, but my lord will kindly come to page 192. Second line from the top at page 192. Has the lordships got it, my lord?
192, yeah.
Yes, second line. Indeed, in the case of consigntees group, precisely this was done, where an application for contempt was filed, which was revived pursuant to the previous order of the court, while doing so had reserved the right to consider on the previous occasion. The question, if the Solicitor General refuses to give consent improperly or on irrelevant ground, court could consider that question. In the case of consigntees group, court went into the reasons given by Solicitor General declining consent. This court in that case held that on examination that such consent was properly refused. This is a complete answer to the contention that in a contempt petition, the ground for either giving consent or not giving consent or for not considering application for consent are justiciable, and that question cannot be gone into in that proceeding, though it must be emphasized that in that proceeding, that Solicitor General was not made a party to the proceeding. So, my lord, this authority judgment is an authority for the proposition that a consent given by the Advocate General is again subject to judicial review. Be it refusal, be it grant. And here in this case, I'm alleging, my lord, the Advocate General has personal animus. And that's why he has dragged me. And my lord, 6 or 7 in TV interviews, my lord, all throughout he is maintaining that there are 3 advocates who is spearheading this movement against shifting of the High Court. Every time. Therefore, my lord, his version cannot be accepted. My lord, I'll make one submission, my lord. I also intend to challenge this, consent, or rather his view. So I'll be filing a petition shortly. My prayer is, my lord, my petition and this should be heard together.
My one-liner response is very clear, Lordship. This is a case under 15A, not under 15B. In 15B, only the consent issue can be raised. 15A, it is a direct filing by the Advocate General. So there's a basic flaw of the arguments forwarded by the other side's counsel. So there's a huge difference between 15A and 15B. The judgment which he is referring, it is relating to 15B, not A.
My lord, can I just take 2 minutes, my lord? Just now, Learned Advocate General has said that it is under 15B. If it is under 15B, my lord, subject to correction, I may be wrong. I don't think, my lord, Advocate General has any scope of standing before the court and arguing the case. His duty would be, my lord, to refer the motion, then the case will be registered as in re so and so.
No.
Can you see, my lord?
What we.
Yes, yes. I may be wrong. That's my understanding.
The Learned Advocate General has said it is not a case of 15B, 1B. It is a case of 15(1)A, where the Advocate General himself has filed the consent question that any other person with the consent in writing of the
Exactly.
is not given any consent.
I'm saying that only, my lord, that Advocate General's motion, that is, everything is subject to judicial review, my lord. Everything is subject to judicial review. My lord, if it is under A, again, I am arguing with all respect, all humility at my command, my lord, there is no scope for the Advocate General to argue the case. He need not stand up here and spend 1 hour's valuable time. His duty is, my lord, this is my understanding, my lord. It can be checked up. His duty is, he will simply write a letter and your lordships will take note of it and then register a case. My lord, it is unheard of. An Advocate General standing before the court and arguing a motion for himself.
Motion for the purpose of motion, he has.
No, my lord.
Raise the
No,
motion.
my lord, I'm saying, subject to correction, my lord. My understanding is, if a motion is by Advocate General, then there is no scope of argument. Be it under A, be it under B, there is no scope of argument. That's why I was shocked yesterday when permission was sought. What is the urgency in a contempt case, my lord? So therefore, my lord, with all respect, my lord, at my command, I'm making this submission, my lord. Lordship, please look into this aspect of law, whether be it a 15A or be it 15B, there is any scope for Advocate General to stand up before lordships and argue a case. It is basically for him to just bring it to a lordship's notice. Then the registry will, my lord, verify it, I mean scrutinize it, then it will be placed, then it will be registered as an in re so and so. His duty is over the moment he brings it to your lordship's notice. Thereafter, it is a matter between the court and the contemnor. That's what the criminal contempt law, as I understand, is. Therefore, my lord, the procedure which my learned friend has adopted is not correct. And lordship may kindly check up this part, my lord. I may be wrong.
On a motion made by.
That's all. That's
This contempt petition has been by the filed to Advocate General under section 15. Section 15, 1A. Read well. Under section 11, 12 and 15A of the Contents of Courts Act 1971. Read with Article 215 of the Constitution of India, alleging that the respondent number 1 has committed criminal contempt by making scandalous remarks against the individual judge as well as the High Court. Stop. The respondent number 2, the respondent number 2, the allegation against the respondent number 2 is this, that the respondent number 1 has made such scandalous remarks with the consent and connivance of him. Full stop. Having heard the learned counsel for learned advocate general, we have heard the learned advocate general at length, as well as the respondent number 2 in his personal capacity. Order reserved.
Deeply obliged.
Deeply obliged. Same. Sir, पानी बोतल दो।
అది బాధలేనా ఉంటాయి
Crossover method 12.
Lordship, some instruction has been received, but it is inadequate, Lordship. Let me file a detailed affidavit explaining all, Lordship. Actually, Lordship, after she retired, she has been given invalid pension. There is two type of law. Both cannot be given. Let me explain all those through an affidavit, Lordship.
Mr. B. Chakrabarti, when a counsel appearing for the respondent raised some more time to clarify the disparity between the PPO dated 17/12/2021 issued to the petitioner and the PPO forwarded to the concerned bank with regard to the element of disability pension, which is missing, which is missing in the PPO is forwarded, missing in the PPO, forwarded to the bank.
Lordship, actually, there is only one PPO has been issued, not two, Lordship. Let me explain all those through an affidavit, Lordship.
Lordship, kindly fix a date.
How much
May,
time?
May, Lordship.
Okay, May, whatever they, both of them this.
Much of the Lordship.
Yes.
For hearing, item 16.
Lordship, written instruction yet not received, Lordship.
Why not received, madam?
Lordship,
The executive officer has to withdraw that consent, whatever the consent he has given.
executive officer newly come, Lordship, so he,
Ask him. We are not going to discuss, entertain any other
Friday,
excuse.
Lordship, Friday.
Immediately revoke it.
Lordship.
Whatever the permission you have granted for using this school park as parking, or otherwise he will be held responsible.
Friday, Lordship.
देखिए, Learned Counsel of Miss R.B. Bora, Learned Counsel, appearing for the respondent number 5, District Commissioner, raised some time to produce the copy of the order passed by the Executive Officer, Tezpur Municipal Board, withdrawing its consent given for using the parking lot of the school in question, the school ground, withdrawing its consent for using school ground of the school in question for parking. Next date, Thursday, day after tomorrow. Get the order, otherwise no, nothing.
Deeply blessed.
Thank you.